Okay, welcome back, everybody. Thank you for joining us here for this panel. The panel conversation we're going to have right now is titled Strategies for Winning on Institution at the PTAB. It's open-ended. It can be strategies that apply to patent owners. It can be strategies that apply to petitioners. And let me just introduce the panel, and then we can start off from there. So from the audience's left to right, we have Matt Johnson, and Matt is Jones Day's primary contact on patent practice before the Patent Trial and Appeal Board, and he has appeared in just shy of 200 cases, and he has advised many clients, including some of the largest petitioners in the world. So, Matt, thank you. And you have a blog, too. You have a blog that writes about this, and that's how I found you many years ago. So thank you for coming. It's good to see you. And next to Matt, we have Brent Babcock, and Brent is chair of Loeb and Loeb's PTAB Trial Practice Group, and he represents high-tech clients in every aspect of intellectual property disputes, focusing on federal district court litigation and PTAB practice. So, Brent, thank you for being here.
Thanks for having me.
And last but not least is Nathan Sportel. And Nathan is a member at Miller & Johnson, and he is a patent attorney, and he specializes in challenging and defending patents before the PTAB as well, both in IPR and PGR proceedings. So thank you, Nathan, for being here. And we have, I think, a pretty good mix of perspective here on this particular panel. I'll ask you guys when your preliminary remarks to go down and maybe at least give folks some idea of what your percentages are. I know we have some that do more petitioner work, some that do more patent owner work, but everybody does all the work across the board. So if you have any questions, please feel free to ask. But Matt, let's start with you. What is your preliminary thought on this particular topic? And if you can give us maybe a breakdown of where you're coming from with respect to what drives your practice.
Sure, and I think that breakdown maybe drives some of my feelings on the topic. Probably about 2/3 of my cases are petitioner cases. Being an electrical engineer and representing some of the larger companies out there, we tend to fall on the petitioner side. I think being a petitioner pre-institution is really stressful, and it's a lot of exercise in paranoia, where on the patent owner side, I think it's a lot more enjoyable. So whenever I can find my way onto a patent owner case, I do that, because I think there's a lot more creative arguing early in a case on the patent owner side. But on the petitioner side, as Jonathan mentioned on the last panel, you really have to be focused on dotting I's, crossing T's, preemptively thinking, testing your case, thinking what arguments is a creative patent owner going to make, and that makes it a lot more stressful.
Okay, great. Thanks, Matt. Brent, your preliminary thoughts.
Yeah, so I think this panel is hopefully going to be balanced and provide perspectives from both sides of the V. As a patent litigator, I handle whatever comes in the door, which means for the same with the IPRs, PGRs, CBMs, derivations. Historically, I think my stats are like 40% petitioner cases, 60% patent owner, but I represented a very prolific NPE at a prior firm, and that kind of skewed my stats towards the patent owner side. So I consider myself roughly 50-50 in my practice. And I think we've heard a lot about petitions and POPRs in the prior panels, and we've had some really good discussion. So we're going to try not to rehash some of those same issues, but I think we have maybe some different perspectives. And we have some ideas about things to talk about that maybe haven't been covered. The first thing I would mention from a patent owner's perspective that I haven't heard discussed yet is the importance of credibility for the board with respect to the claims you're going to defend. I think disclaimer is a tool that should be considered very, very seriously by you as the practitioner, by your client, and by litigation counsel. Sometimes we are litigation counsel, so it's easy. Sometimes we're not. And as PTAB practitioners, we're kind of the tail. The litigators are kind of the dog. And they have broad claims that they have great infringement reads on, and those are the claims that they want to hug, and they're golden claims, and those tend to be the ones, of course, are the broadest claims and the ones that are most subject to challenge. So I think it's important early on in that discussion with your client and with the litigation people that you look at the claims, and if they are invalid, don't hang on to them. You're going to lose your credibility with the judges. You're certainly going to get instituted. And at the end of the day, when the judges look at you at the final hearing and you want to talk about the narrow claims, and the judge is going to want to talk about the broad ones. And when you go hemina, I'll rely on my papers for those, the judges are going to sit back and say, we don't believe you on those claims, and we don't believe you on any of your claims. So we've talked a lot about the importance of vetting claims and pressure testing. I think Richard talked about pressure testing claims before you sue. Most of my clients don't do that. They don't want to know what the art is. They don't want to find out what could be a landmine. We have a great infringement read. So you have to be prepared for good art and be prepared to jettison claims that you can't win on. The problem we have as lawyers is, someone above us, a client or a litigation counsel, will say, give it a shot. Make the argument, see what happens. They're not the ones in front of the judges actually looking them in the eye and saying, this is my argument, because the judge is going to look at you and say, I don't believe you. So you have the courage in your practice to say, I can't defend this claim in light of this art. We can't win. And if I lose this claim, I'm losing them all. So that's probably my first point I want to make.
Great, excellent. Good. We'll come back to that. And Nathan.
Yeah, I'm a little more petitioner heavy in my practice. I think it's been about 80% has been on the petitioner side. And I guess my thing that I want to stress is the importance of finding your best prior art and developing the skill to find it yourself in some situations, right? So maybe that's easy for me to say as a former examiner, but there's so many graded tools that are out there that if you spend some time on and you learn well enough, you can go out there and find some prior art. All of my best petitions have been art that I found on my own. We can all hire somebody from India for $1,000 or whatever it is that can give you a bunch of references, but they may not be the best. They may not understand the case. They may not understand the way the claims are being construed in a way. So I really want to stress that, and especially if you can try and find foreign prior art, right? When the whole PTAB system was created, I think there's some legislative history that said we need to be able to identify foreign prior art that the examiner may not have been able to consider. So if you can find that, that's sort of the gold standard of prior art that you can find.
Okay, great. That's a good start here. So there was one thing that has come up throughout the day today primarily, and Matt, you touched on it a little bit there in the opening, and we were just chit-chatting about it before we started, and it's about the petitioner has to get everything right in the petition. I will confess, when I heard that, I thought it was a little bit BS. And then the more I thought about it, and the more of you that have said it, and I think, okay, well, I've heard it once, so now the second time I heard it, I'm more receptive to it. And now the third time I've heard it, I think maybe I get it. But I want to probe that point a little bit more. Is it because you as the petitioner really only in this age, by and large, have one bite at the apple because of the serial petitions, and because, or the diminution of the serial petitions, and because there's a 1/3 rate of denial at institution, or what drives that in particular?
I mean, I think it's just PTAB case law and policy require the petitioner, and I mean, it makes sense that you're potentially taking a property right away from the patent owner. So you need to put them on notice of what your case is up front, because these are really fast-paced trials, 18 months. There's only a limited number of briefs through the matter. So it wouldn't be fair to kind of make a notice pleading at the petition stage and then jump in at the petitioner reply and say, well, I really wasn't talking about this embodiment in this prior art reference. It's also shown over here, even though you convincingly showed that it wasn't in what I pointed to at the petition. So it's not fair to the patent owner to be able to shift your case through the matter. So the PTAB has required that you have to lay out your entire case at the petition stage, and your ability to shift or add evidence late in the matter is very limited. And if you're making your case in your petition and maybe dependent claim 10, you think it's kind of a dumb limitation and you don't put the work in on proving up motivation to combine there, the patent owner is going to see that and say, there's a weakness. They didn't do their legwork there, and I can make a colorable infringement case there. So I'm going to focus there, and because they didn't dot their I's, cross their T's, I have the potential to get a viable infringed case out of this matter, potentially with estoppel. So any little crack in your case is something that patent owners are going to be looking at and trying to, because they only need one infringed claim at the end of the day, so they only need to rescue one claim. So, and because you're not allowed to supplement your case later in a PTAB matter, you have to do all that right up front.
Okay, and you all agree?
Yeah, we're nodding here. I think
Yeah, I see.
For petitioner, it really is a laundry list of items, the boxes you have to tick. You have to tick all of the claims, all the limitations. You got to make sure you go through all the claim construction issues. You got to make sure you go through the reasons to combine, likelihood of motivation to combine. You've got to put in, likelihood of success. All the things that you want to put in, you've got to put it in your petition. And it's easy to forget those or to gloss over them. And as Matt's saying, that's the patent owner has the benefit of addressing one of those little threads that maybe you forgot or you didn't address thoroughly, and that will be a focus, a rifle shot in the POPR or maybe in the case to say, hey, your petition was light or didn't address this issue. I think we often look for missing limitations, because there's a kind of a, here's the big claim, and you put it in the claim chart, and you read it out of the prior art, but there's something in that big paragraph that isn't really addressed in the art. And your associate writes it up, says everything's there, but when you look at it carefully, it's not. So ticking every box is really important.
Okay, Nathan, anything to add?
Yeah, I mean, it comes down to every limitation, and it also goes to how you're applying the law, right? Like we always talk about motivation and combined. Well, there's also reasonable expectation of success. You not only have to think about why you'd combine references, but what it's going to end up looking like when they're actually combined, and that maybe it doesn't make sense to combine them, and there's a pretty good argument for that. So you really need to vet even that. The petition is setting the stage for the whole case. There's not really a developing of it. So you need to have it perfect, exactly how you want it, as perfect as it can get at the petition stage. That's setting the stage for the whole IPR, so it really needs to be thorough.
Matt?
Yeah, the system's set up so that it's petitioner's burden to make their case, and you look through the claim set and you say, these are silly claims. They're not really adding anything. There shouldn't be any patentability there. But if you don't do your work on those claims, it's a viable argument for the patent owner that you just didn't make your case. Whether or not that I can make an argument for patentability, that's not what matters. It's that you didn't do your job, petitioner, and so I have a claim free and clear out of the PTAB.
Yeah, I would add to this that a lot of times the project comes and the decision to file the IPR has already been made, and I strongly advise that you have to first find the art before you make this decision to file the IPR. The art is so important, and if I think there's a disservice for counsel because we all get these emails every morning or every day that says, hey, we'll do a prior art search for $500. We'll do a clearance search for $1,000, right? And so clients and litigators who don't do this kind of work say, hey, look, here's $1,000. Go get go do your search and then file an IPR. And I never find those searches helpful at all. I think you have to first say, look, hold on. Let's see what the art is before we make a decision that we're going to spend $750,000 on an IPR. And you can do it in stages, obviously. You could do the quick and dirty, and you have to do an objective analysis of that art, and a lot of times it's crap. And you have to say, look, this isn't any good. We need to go back. We need to find. And I think Nathan's suggestion is correct, that we lawyers are hungry and we know what to look for. And so you have to find an associate or a searcher who isn't just going to do a word search in some database and spit out a bunch of results and say, here's my search results, run with it, because those are rarely useful. A lot of the stuff is in drawings and diagrams. It's on the internet in like chat rooms or whatever. There's stuff all over the place that you have to dig for, and most of the search firms aren't finding that stuff. So do the digging, do your homework, make sure that you're comfortable that you've got great combinations, 2 or 3 references at the most. You got all limitations covered. And if you don't find it, you got to have a heart-to-heart with your client and with litigation counsel. Say, look, we're going to lose, and not only are we going to lose, but this patent's going to look really good to the jury, because you better believe that at trial, not only will they wave the seal and the blue ribbon around, but they're going to wave around the fact that this patent didn't even get it. There wasn't even a decision on institution. It was denied. But the same lawyers who tried to kill this patent here in front of you, jury, they tried the patent office, and the patent office said not even good enough. So there's no formal estoppel, but that's effective estoppel. It's essentially trying to get that patent invalid in front of a jury after the patent office has said thumbs down. That's worse than just having left it alone.
So let me ask you, and maybe it's just what we've been talking about here right now, but if you had to put your finger, each of your responses, your finger on what is the primary reason why petitions are not instituted. And maybe it's unfair to give you a primary, ask for a single reason, but I'm going to do it anyway, just to see, like, what's your number one reason, like, when you're drafting a petition. Matt, I'll start with you and we can go down the line here. When you're drafting a petition, what's the number one thing you tell your new associates who are helping you, and don't forget,
Sure.
because we get in trouble, it's a big faux pas, whatever.
Yeah, I mean, as folks said, the prior art drives the matter, but there's so many other things. We had the panel on missteps, little things that you can miss. I's not dotted, T's not crossed. That can cost you at the petition stage. Not preemptively addressing certain arguments that it's clear that the patent owner is likely to make, discretionary denial issues, 325D issues, proving up prior art references, or proving up references as printed publication. So many petitions get denied for that, where in some cases it's a close call, a conference post or something like that. But for things that are in journals, in libraries, we shouldn't be losing cases on those. And attention to detail after prior art is critical. And a lot of petitions, you scroll through Docket Navigator each morning to see what cases got instituted, what didn't, and why. A lot of cases fall by the wayside that maybe have some merit due to just a lack of attention to detail.
Okay, great. I'll go to Nathan first on this, next rather.
Sure. The one I've seen the most is probably people misinterpreting the prior art in a way that is beneficial to their case. It almost feels like they're trying to put one past the board and put one past the petitioner, right, or the patent owner. That's.
Do you think it's that, or they're really trying to put one past themselves?
It could honestly be that too, or they misinterpret it. They just don't understand what it's really saying. They don't know the field as well as the patent owner. But that's the one, and the other one is a failure to effectively explain what the resulting combination is going to be, right? So we might have this reference that says A and B, and this reference says C. And there's some motivation that's pretty well accepted, but what actually happens when you put A and B with C, and what other things did C teach that might suggest that it's not going to work real well with A and B. So those are the two things I've seen as this sort of failure to reasonably get the reasonable expectation of success fully explained in a way that the resulting combination is explained to the board in a way that they're going to understand, and then misinterpreting the prior art.
Brent?
So I agree with all of that. I think the one I would add is that plaintiffs, patent owners tend to gloss over the intricacies of claim language and how claim limitations interrelate to each other. And so they'll read a long claim and they'll say, yeah, okay, it's infringed. And that's how they read the claim on the prior art. A lot of times the claim is more complicated than it looks to be on its face. And so it's very important to really study. I think, I tell my associates, every time you read the patent and you read the claims, you're going to learn something. You're going to see stuff you didn't see before. You're going to see relationships in the claim language that you didn't actually appreciate. I see that piece has to be, therefore, said thing has to do this. And so I think a lot of times in the petition, you'll see maybe glossing over of claim language, and the patent owner points out, it says, wait a second, the claim actually requires this, and this part here has to be there, and there's nothing in the prior art that shows that. So be very, really diligent in reading your claims over again, repeatedly, and make sure you understand how the claim operates as a whole, and not just do the infringer gloss over, which is, I don't know how many times I read a claim. The first time I read it, I say, oh yeah, it's a pretty broad claim, And then somebody says, what about this and what about that? And look at the claim and look at the spec here. He's like, oh yeah, that claim isn't quite as broad, is it? Because it requires this. And it's actually in the claim language, but it's something you don't necessarily see unless you really study it.
And I think that's a great lesson for patent prosecution. You talked about what do you take away for patent prosecution is weaving the invention through the entirety of the claim makes it a lot harder to attack, where it's not just pieces tacked on, glued to one another, but to tell the story of the invention through the entirety of the claim at the start and as you make amendments is something I see a lot of claims where that's not necessarily the fact.
Mm. Yeah. So let me ask you this in terms of institution, again, from like the petitioner's perspective in particular. Do you see more failures to institute when they're going after when they maybe fail to maybe this is just picking up what you said, because I have in my head, and we have a lot of in-house counsel come here, and increasingly over the years I've heard more and more and more of them say, I want a picture claim. I'm not afraid of picture claims. We're making money selling X. I want a claim that covers exactly X. And I don't think enough patent prosecutors do that. So maybe I can get your comment on that and see where that conversation goes while I try and figure out how to ask that question, because it seems like there maybe is some characteristics, what I'm looking for, probing the characteristics of petitions that more likely to fail versus those that are more likely to succeed. And now I'm thinking about claim strategy that was maybe very thoughtful, and versus claim strategy was just, I got to write claims. I only have another $250 on my budget to write the claims after I get done with the spec. So what do I do? But go ahead, Matt.
Yeah, I mean, I think the tendency when you're drafting that first set of claims is to, maybe because the client's isn't gonna file continuations, is to go broad and then inch towards the line. But I think if you can counsel a client to think longer term and continuation practice that we were talking about earlier, a middle of the road claim in the first application of the family, I think can be very, very valuable. Not only from being more defensible, but it allows you to work with the examiner to get the examiner on board that there is an invention here. And now that we have one patent in hand, let's work to broaden things up and explore the bounds of that invention, but not being afraid for a mid-breath claim to start. If you can convince your clients to keep a con available, I think it makes for a lot more formidable patent families.
Okay, Brent.
So we have a really sophisticated audience, and you're addressing companies that have sophisticated patent practices, that's not typically what I see. I mean, I think the general prosecution out there is, Scott mentioned commoditization. It's on a low budget, and the goal is broad claims. Get them broad, so you got a great infringement case. And keep a continuation alive. Try to get the broader claims in the continuation, right? I mean, you got the examiner on board, so they can get a continuation and get those claims that you couldn't get in the first, in the first case, and keep that alive. So their focus is always on breadth of claims. And I get that, and there's a lot of pushback here because people say, well, now the patent office has granted this patent. That patent hasn't really been tested. And so the trade-off for getting really broad claims is that it's going to be subject to attack. And so again, I go back to the point of when we're thinking about an IPR or PGR, look at those claims, those broad claims, with a lot of suspicion, and say, these are probably going to be, be subject to invalidation. And when the art is presented to you as the patent owner, be ready to say, yeah, that's pretty darn good art, and not, well, I'm an advocate, I'm a good litigator, I can win anything, let me go fight it out, because the judges at the board don't care, how coiffed your hair is or how polished your shoes are. If the art is really good, they're going to kill the patent. It doesn't matter how good your advocacy is.
Nathan?
Yeah, I mean, I think your original point is something that I go back to, this idea that maybe more of us need to be sort of generalists in the patent field, right? Or at least have some exposure to both the prosecution side and the litigation side. When you can write a claim knowing what might get challenged in litigation, that's a really powerful tool. And if you can litigate knowing all the things that went into the prosecution of it, it makes you stronger in there as well. Like, I recently had a case where we won because the letter S was placed on one of the words. And because it was plural, we got the institution denied. And nobody had considered that part. But and it wasn't argued about in prosecution or anything like that, but it's something that we understood, going back to your idea of this claim as a whole language. That's so critical that you think about it all together as a claim. And I think a picture type claim or something like that is a way that you can really sort of tie the whole thing together and create a unique invention as a whole when the claim is written.
Mm-hmm. Yeah, when the one thing that comes to mind, listen to all of you talking, and it just dawned on me, it's like, why hasn't this dawned on me at all for the day? We keep talking about how much time, money, and energy goes into the searching on the IPR level, and it's not nearly what goes on at the application level, and and not only is it not nearly what goes on the application level, is sometimes there's no searching at the application level.
Oh, that's exactly right.
We don't. It's not in our budget. And it's like, so the person who's drafting the claims is just shooting in the wind, hoping that I'm going to claim what you put in front of me on my desk. Write a claim to that, not knowing at all whether or not there's something out there that I don't know, could find, or anything. And that, I think, is frustrating. I've just never understood. I mean, I get it. It's on some level. Back in the day when you'd get the big portfolio and you're infringing something, if you're not infringing this one, you're infringing something, so take a license. But increasingly over the years, as injunctions have kind of gone away and as damages have ratcheted down and as the PTAB has come up, that kind of head in the sand at the application level just strikes me as ridiculous.
But that's... You're preaching to a very sophisticated crowd. I mean, the patent of the 500,000 that are filed or 600,000 are filed, very few of those people are thinking that long term. Mm-hmm. They have a limited budget. Yep. They get rewarded for getting patents granted, yep. And investors come when they have issued patents, or at least they have potential to sell the company if they've got granted patents, right? Mm-hmm. So that's the first objective, is get the patents filed. We don't want to know the art. We don't want to sink our own boat.
Right.
We don't want to understand what might happen way down in the future. So Richard,
Yeah, go ahead, Richard.
and obviously you guys are different. I mean, you guys are much more sophisticated than that.
I don't know about that, but I just want to comment on Gene's point that we're sort of shooting in the dark. And that's my experience. That's never the case because we're talking to the vendor and we're saying, okay, what problem is this solving? Why is it sufficient? Or why is it product? So we're getting a good picture of what we believe is the invention and why it's the next best thing since sliced bread. So we're drafting applications with that mindset, right? It's not that we don't want to know what the prior art is, we just don't have the time or the budget for that, to do that. If we had unlimited, we would definitely do conducted prior art, but we can't do that for every application.
No, you can't do it for every application, but I'll just push back a little bit based on my own experience. So often in my career, when I was drafting applications, the inventor would come to me and tell me what the invention is. And I could almost 100% of the time find exactly what they told me the invention was. And then they would, because I did my own searches, and then if it, at least initially, and then if it looked good and there was some value to this, and I did a lot of work for startups, so we were doing maybe a lot more searching because the search report, my opinion letter, the provisional application that we file all went together in a package of a business plan to try and raise money, right? But I would always find what they told me the invention was, and invariably, I would send it to them because you don't ever want to put bad, unless they force you, you don't put bad news in writing. And I would send the patent and say, I want you to take a look at this and this patent and give me a call. And I get a call or sometimes an email back saying, this is great news. You didn't find my invention. And I'm like, okay, Skippy, we need to sit down and talk because I found everything that you told me. So I need to understand from you now. So I actually went, and I did a lot of software, as many of you know, a lot of software work. So I actually got to the point where I would not ever send it out to a searcher until I did the first search, because I knew when I gave them the results, they were going to be ecstatic I didn't find it, and of course I had found it. And now this is the first time that they can articulate to me why their invention is different than what I have already found. So, you know, I just think it's ships passing in the night. A lot of the inventors don't know what's important, even the ones that are sophisticated, that have gone through this before. They're never going to be as sophisticated as we are.
And I think that the proof is really, in my experience, you know, when I get a patent, either I'm attacking or I'm asserting, it's really easy to determine how much effort was done in the prior search. You look at the IDSs in the file wrapper, and I'd say 90%, maybe that's too high, but a large percentage, there was no initial IDS filed by the patent, by the applicant, right? Or maybe a couple references, you know. And a lot of times I see a patent, and the only references cited were pulled up by the examiner, who did a search and got like 6 references, right? And it's a crowded art, and you're like, okay, so come on, that's clearly head in the sand. I mean, even your client knew of some background art that could have been submitted just as, you know, in Europe as a reference or something, you know, just something that's relevant to this technology. So if once in a while you'll see the opposite. You'll see, you know, 3 pages of references cited, right? So the applicant decides, okay, I'm going to submit everything under the sun. So now I've got 300 references in the boxes that one of our panelists mentioned, you know, and then that's kind of done for a whole different purpose, right? So hopefully, you know, I think the approach probably should be exactly as you said, Richard, which is when you get ready to think about asserting, before you do, pressure test the patent. Say, this is one that we have a huge portfolio. This is one that's we think is really important, but, you know, we didn't spend as much time on this one as we probably could have. We didn't know at the time it was going to be super valuable. Let's send it out to a firm. You know, let's have a firm pressure test this. Pretend that they're going to attack this patent. Let's give them $50,000, $100,000 to find art and tell us what they think. And then if it survives that test, now, of course, there's all kinds of issues about, well, you got continuations, and now do you have to disclose that for your duty of candor? I know there's a lot of complications why people don't want to know what's out there, but at the same time, if you don't do it, the other side's going to. I'm gonna if I'm the one attacking it, I'm gonna spend that time and money to find the art, and then you're already down the road. So it's certainly, I think, worth at least talking about, do we pressure test this up front, because the art's going to come out. And I know I don't want to dominate here, but I do.
No.
There was one comment. There was a discussion about examination searching and examiners kind of giving the patent and then the patent office taking it back. And I do think that the ex parte process is wholly different than the inter partes process. And to expect to get the same outcome from an ex parte process where you have a patent owner working with the examiner, it's like, if I were, I mentioned this to Judge Kim, if I were accusing you of infringement and I went just to the judge with my case against you and you didn't get a chance to say anything, I bet I'd get a pretty good decision that you infringe. Mm-hmm. The minute you step up and say, wait a second, let me explain my product better and why I don't infringe, you're going to get a different answer. And the same thing happens in the IPR process. I mean, you're going to do okay with ex parte, but you're going to do, the inter partes process is going to, you're going to definitely get the better answer, at least the truer answer. It's just like we have an adversarial litigation system, right? A versus B. Both sides get to fight, and the truth will come out.
Mm-hmm.
Just a
Sure.
second your sanity check at the application drafting stage of things, and doing a couple hours as the drafter. I mean, especially in the software art, there is some art in the process of how much you disclose in the specification, and if you don't know where the invention is, what the prior art is, you can't ask those questions to make sure that you have enough disclosure in there without disclosing too much. You don't need to give, in most cases, code level of detail, but at what level of abstraction do you need to get to have a good shot at getting claims? So that hour or two of sanity check, searching, even if it's hard to bill on low budgets, is worthwhile for getting your client good patent assets on the back end.
Yeah, and it's at a time when you can actually do something about it. Because by the time you start to enforce or start a licensing campaign, the patent is what it is. It's too late to do. You may have some continuations pending, but unless you're going to file a continuation in part, in the most extreme situation, it's going to be set in stone, and even then, it's going to be, you've given up so much term by that point usually for a continuation in part. And I get the budgets, and I understand the problems, and I know that you're trying to do so much with it. It's just the system right now it's not favorable. And one of the things that's been popping in my mind repeatedly, and I don't know how you would do this, but it seems like from the patent owner perspective, there's not a care in the world about whether you reasonably detrimentally relied on getting this asset. Now, if you stuck your head in the sand like an ostrich and didn't do any searching and didn't know what was going out there, and you did sort of like, we're patting each other on the back because we got a pencil claim, and it's so broad and that sort of thing, okay? But if you did, cross your T's and dotted your I's, and you got a reasonably narrow patent, and you're using it, and you build a company around it, and there's some detrimental reliance, it just feels like there should be some different, that should be looked at differently. And I know it's not, but it feels like that there's some room here for everybody to look at what this means, and I think that may be why. And Scott, you may have some knowledge about this. Is that what's really going on? What they're trying to not give a carve out for independent inventors, but some kind of consideration for independent inventors to recognize something like that
in the legislation.
In the legislation.
Yeah, I mean, that's what I think some of the senators out of Texas are pushing, is an opt-out for micro entities or somehow folks with a certain level of income, would be excluded. But
that's not substantive. That's not like based on detrimental reliance or any kind of
it's all
due
economics.
diligence, or
Yeah.
it's just hey, you're not the type of person we want to subject to this, right?
Yeah, I mean, it's all about if the original inventor is still involved, right, hasn't sold it to some non-practicing entity. It's trying to protect, the Josh Malones of the world that are, have a product out there still.
And only makes $30 million a year selling it, right?
Yes, he's
Yeah.
sympathetic.
Yeah.
People like him, yeah.
Okay. So, does anybody have any question? I think I saw Steve. You had a question?
Yeah, I had a thought about Brett, your comment about the inter-parties aspect versus ex-party aspect. I think it's an interesting comment. It just sort of made me think. I wonder, I've never looked at this, but what the statistics look like for inter-parties re-exams and how those proceedings compare to PTAB proceedings. And I'll bet, without having looked at it, that the statistics are a lot more skewed in the case of PTAB outcomes compared to inter-parties re-exams. Like I said, I've never looked at it.
Yeah, I haven't either, but I know that was an attempt to take the ex-party re-exam, right? And the complaint we all had as litigators was like, why would in the world would I take my best art and give it to the patent office and have them whitewash it and bless it? Because at that point, I've now shot myself in the foot. So inter-parties re-exam was supposed to be, the solution. And I think that, that prompted the AIA, right? That whole idea of let's make this inter-parties, let's take re-exam, let's take the inter-parties re-exam, kind of amp it up, use the interference rules as kind of our trials rules, and let's put it together and make a new proceeding that gets us the inter-parties. I mean, McKelvey back in the 90s, he was all into making this litigation, right? This patent office stuff should be like mini litigation, pseudo litigation. You should have depositions, cross examinations. You should have FRE should apply. You should have live hearings. We should be able to assess credibility. I mean, I had depositions in front of McKelvey on credibility, on inventor credibility. He wanted to see people face to face, and we had a discussion outside about the importance. And one of the drawbacks in these proceedings is that I think the judges, no offense, don't really want to get into, credibility determinations, because it's almost like it's an accusation that someone's not being honest, and the judges don't want to deal with that. They want this is the claim, this is the prior art, that we're going to deal with merits. Don't throw all your mud in our nice PTAB, right? We don't want that. That's district court litigation. You guys can spit at each other. We don't want to hear that. But it really isn't an aspersion on an individual, say they're dishonest. It's just so many times, you look at the experts and when I depose them, you can see they're not being honest. But on the transcript, on the cold transcript, he paused for 30 seconds before he said yes, and he was doing all this, but judges never see that. They say, as a question, answer yes. It looks like he was being very candid. So I think we have a ways to go before we get to a process that mirrors McKelvey's dream of making this like mini litigation, because it's still, I think, a lot of paper that you lose some of the flavor.
The reason we ended up with the system we have in large part was due to the way inter-parties re-examination really didn't work. So on average, right, it took something like 6 years to get through the system. So you're going through the examination phase with the examiners, you go to the BPAI at the time, then you get up to the federal circuit. There were all kinds of petitions in sort of a prosecution sense that slowed things down. Patent owners complained that the grant rate was over 90%, so we changed the standard. They didn't get a chance to say anything before a decision was made, so we have the preliminary response. It took too long, so now it's done in 18 months. So a lot of the mechanisms that we have were specifically directed to criticisms of inter-parties re-examination, which back in those days was used not so much as an alternative to litigation, but I'll wait until I get a bad markman, or I'll wait until I get an adverse verdict, and then I'll run to the patent office and I'll complain that they're not fast enough. So now we have the 12-month window. So a lot of the ideas you see in the AIA came directly from lessons learned in inter-parties re-examination.
I think trying to compare results from inter-parties re-exam to IPRs is tough because I don't know how many inter-parties re-exams ever actually got to the official finish line. But you know, they were, you know, used I think sometimes as a backstop for an injunction if you know, but they oftentimes were finishing way after the trial court was long done in the appeal. So I think we're in a better spot.
So that's what I was just going to say. There were cases where I know, and Jay, when you were there, I think this happened, right? There was a high-profile case, and I can't remember the name of it. The appeal, the whole appeal was over. The settlement had been paid, and then an inter-parties re-exam, the patent was invalidated. This was like.
The research in motion, NTP.
It may be. It may be. I don't know that that's the one I have in mind, but that sort of, I think that's very similarly happened there too.
So, you know, I gotta say, I've decided a few of those appeals on the inter-party re-exam, and the process was just horrific. I need a bigger adjective than that. You know, the poor examiner in the CRU would be like, I got a petition. I don't know what to do with it. So they send it over to Oakland for a decision. And Oakland says, well, I don't have to do the work. I'm granting it. And you would have thousands of these things granted and too many documents to even read.
Yeah.
I mean, 1,000 and the page limits. Well, what were the page limits? I'm not sure
There were none.
There we are.
You would have a 300-page request come in with 55 proposed rejections because people thought, well, if I'm going to be stopped,
Yeah.
I'm throwing in
Throwing it
everything.
all in. Yeah.
And all of that stuff would be in there, and it just took forever.
Yeah, and it wasn't uncommon that these things took 6, 7, 8 years.
And I had somebody submit in 5-point type.
Oh my God! Why would you do that without a page limit? Just they didn't like you.
Well, in the
There was a test to see whether your eyesight was really good or not. Right? Yeah. So, Scott, any questions for the panel?
No, I mean, more of a comment. I mean, I think the picture claim is an interesting point. And this gets back to the prosecution points we made earlier, is if someone understands your business and can draft a picture claim with elements that are necessarily in your product, but you're not going to find them in a patent or printed publication because they're written for people of skill in the art that know that stuff is there. So when it comes time to challenge those claims, you now have 2, 3, 4 references, and yeah, all of that stuff might be standard, but it looks a lot different than that one broad claim where you've got 1 or 2, so, you know, 1 or 2 references in combination. So that can be an effective way to insulate somewhat your portfolio from being challenged. I've challenged patents that had claims, you know, longer than my arm that didn't say anything, but you know, they end up getting denied because of all of that stuff that's in there. It, you know, it seems somewhat random, and it isn't, but it, you know, the longer, you know, kind of looks valid, right? It's a really long claim, and so picture claims, I think, are very helpful. Very common in the semiconductor art. You see ranges and equations that again go to pretty much basic properties of certain circuits and semiconductors, but good luck finding that stuff. Good luck explaining the math, and so these are. Some people are evolving and learning that, you know, there are some things you can do in prosecution to make it more difficult to challenge your patent. So,
Yeah.
I think the creative claim drafting and, you know, putting limitations in that are in the art but not there is difficult for petitioners and the PTAB. But, you know, sometimes the best way to show that is maybe through some sort of teardown or testing. But with the PTAB having such limited briefing, it's difficult to pressure test testing, and you know, so it puts petitioners in a bind where you can't find patents printed publications that explicitly talk about limitations. That, you know, and inherency is a dirty word. Just that's standard.
Does that ever work at the PTAB?
I know it has once.
Once.
Once, yeah.
I control F petitions for the word inherency, and that's as a patent owner, that's an immediate spot to try to attack.
Right. Because it doesn't, I mean, it comes up, examiners bring it up probably way more often than they should, but examiners always fail at it too.
Yeah.
You know, because it's just, the law is not in favor of denying a claim for inherency.
Yeah, necessarily present is just too high a bar, I think,
Yeah.
but it's not up to me either.
Right.
And if it's necessarily present, you should have no problem finding some corroboration.
No kidding.
I mean, the problem comes when the litigation team insists that they have an anticipation case. You're telling them, no, we can't say the entire element is missing. And it's, well, we can't be inconsistent in the district court. We already said it's anticipation, so you need to figure it out. That's why people file.
Yeah, because you're Merlin. Just make it happen.
Well,
Wave
but
a
that's why
magic
people
wand.
file those particular. The litigation strategy drives the PTAB strategy, and then you get a bad result.
Yeah.
And that's just the way it works.
So let me ask you this then, following up on that. Like, when do you guys get brought in? Are you brought in by the litigation counsel more often than not, or are you? I mean, because that's always been a big problem, right? Like whoever the client listens to first it controls the case, and often it's not us. It's some litigator who comes up with this argument that's just not defensible, and now because they don't want to go back to the court and say, oh, we've discovered that we need to withdraw that argument, then you need to make this work. And
So it's a mixed bag. I mean, again, we take the work that comes in. Sometimes if it's my litigation case or my firm's litigation case, it's a lot easier, right? Because you're
Right.
involved from day one. When we pitch new work, I always say we pitch litigation and PTAB together and let the client know these are part and parcel of the same issue. So if we're going to defend or we're going to assert, we need to make sure we're thinking about both of these, and that way we don't run into this problem. But I do have cases that come in as, okay, litigation is ongoing. I know anything about it. It's already up to, through Markman, and now here's the petition that just came in. You're going to defend it, and yeah, you're in that spot, which is we've already made these arguments, and you've got to conform your PTAB strategy to the litigation strategy, as Scott is saying, and that's why I say the litigation is often the dog and we're the tail.
so how often do you suppose, to tie it into what we're talking about here, that is the result of the cases not being instituted?
I think it's a lot of the cases we get, the patent or the accused infringer is dead set on filing a petition quickly. They want to get out from under the costs of discovery, and so they say we're going to file this ASAP no matter what, and then we have to go and find the prior art, which makes a petition. But it also becomes difficult because you're not letting the case get into the claim construction phase, and so one of the challenges is whether there's claim terms that just aren't clear at that early stage. How do you take a position on prior art without putting yourself in a bad spot on non-infringement back at the trial court later? It's always easier as a petitioner if the patent owner has spoken first, given preliminary constructions of claim terms. But the drive to file quickly, often doesn't let that play out, and it makes for a tough spot for petitioners.
Mm-hmm.
Go
ahead.
I'm sorry. I was just going
go
to say that I've seen it play out where, you're not exactly sure how the patent owner is going to do something. So we actually did a case once where we saw, okay, he could interpret it this way or this way. Oddly enough, this was the case that created those terrorist stipulations. So you're welcome or I'm sorry, depending on who you are. And we took both positions. So we said, if he's going to construe the claim in the prior art in this way, these are our grounds. And if they're going to construe it in this way, these are our grounds. And with the way that the Supreme Court said it, they're picking the whole petition as it is. So we moved forward. The patent owner basically never took a side. They just didn't say how they were interpreting the claims, and they tried to dodge it. And of course, when oral argument came, they were sort of forced to, and they never did, and credibility was gone, of course, there. But that's one way you can do it, is just sort of try and cover all your bases with different grounds.
Mm-hmm. Okay.
There's two more issues that,
Sure.
as a panel, we talked about that I think maybe haven't been directly addressed today. So I wanted to
Sure,
just
go ahead.
throw those out. The first is expert selection, both by petitioner and by patent owner. And I think oftentimes lawyers use services, the expert services, who promise to provide a great expert, and the expert is probably highly skilled at taking depositions and has probably done trial testimony, and so they are polished. Unfortunately, they're probably a generalist. They may have if it's a complicated semiconductor case that may have a double E, but they don't have specific technical expertise in the area at issue. So the litigators love this expert because he or she has been tried and tested in the in the fires of depositions. But I think they're subject to a lot of scrutiny by the board when that expert doesn't really have any expertise in the specific area of technology at issue in the IPR PGR. So I generally recommend that you obviously want to try to find somebody that has a lot of experience, but I lean more towards getting the expert who's an academic, who has direct experience in the technology at issue in the dispute. Maybe only been deposed once or twice, but they've studied this, they've researched this, it was their PhD. But find someone that really knows this stuff, because again, they're not going to be in front of a jury, and the judges are going to be forgiving if the expert is, they're not even going to see the expert was nervous, but they're going to be forgiving if the expert isn't as polished and good looking as maybe a jury expert's going to be. So find someone. The jury consult or the expert consultant is going to try to pound a round square into a round peg into a square hole because they get commission based upon getting someone placed. And you can see what they offer, but do your own search, and a lot of times you'll find the best expert on your own at some university who has published in this area or he wrote the book. I mean, it's great to say my expert wrote the book on this, so. That's issue one. The second one, and my panelists can elaborate too. If you're the patent owner, know what, this is a term that nobody wants to use, the gee whiz, but know what the gee whiz is of your patent, because I was asked by a Federal Circuit panel, they don't want to hear about don't want to hear the claim. Just tell me in an elevator pitch, what's the gee whiz? What does this invention do? What's cool about it? And you better be able to say it in a sentence, why this is a really cool invention. And if you can't, if you're going to say, well, the claims require this, they require that, and you're going to lose them. So be able to articulate, and you want to put this, in your patent owner response, through your preliminary response. And not pages, just a quick explanation of why this is really a cool development. Why is this an innovation? Why is this an invention? And if you do get asked by a APJ, who probably won't, but about a Federal Circuit judge, what is this invention about? What's the gee whiz here? You want to be able to have a really good answer. And if you don't, come up with one.
Yeah, on the expert front, it's the balance between getting the true expert in the area or the hired gun who understands patent law, and I'd love to be able to get the true expert in the field, but you guys are just good, and you cross up my real expert with claim construction that he just doesn't get because he doesn't have a reg number, and so oftentimes there's a temptation to get the hired gun who's been in 100 cases, maybe doesn't have exactly the technical expertise. On the gee whiz point, a number of panels have talked about what arguments to hold back in the preliminary response and what to point in. And I think there's real art in that, but at a minimum, even if you're going to hold back some of your arguments, I think you want to get the judges comfortable that there's potentially something here. There's a little bit of an invention story, and yeah, maybe we're not going to get to all the details of that till after institution 6 months from now. But I think it's really tough if the judges who write the institution decision write 30 pages why you're more likely than not to lose. If you haven't given them any preview about why there's potentially something here, it's going to be really hard to turn the table later. So at least telling a bit of that gee whiz story in the patent owner preliminary response, I think is pretty critical.
Yeah, completely agree. I mean, I mentioned that case we won because it was a plural noun in our case. That was the gee whiz thing. It was we could control and create different sizes of. I won't get into too far of the details, but it was because of that S that we were able to do that, and we went in great length to explain why that's so important that that's a plural noun, and that's what makes this a unique innovation over the prior art, and it worked.
Okay. Well, awesome. We're right at time, and I really appreciate it. That was a great conversation. Thank you very much.
Pleasure.
Thank you.
Thanks, Jake.